Ladies and gentlemen, please welcome Honorable Justice K.V. Vishwanathan, Honorable Justice Manmohan, Judge Delhi High Court, Honorable Justice Suman, Shyam, and the Honorable Speakers for this session, Mr. Vikramjit Banerjee, Additional Solicitor General of India, and Mr. Saikrishna Rajagopal. Now, friends, it's a very, very critical and crucial subject. The Honorable Chair and Speakers are going to speak on intellectual property rights in a borderless world. Now, I would request Mr. Apurva Kumar Sharma to welcome Honorable Justice K.V. Vishwanathan, Judge Supreme Court of India. मैंने बोल दिया वो बुके मंगवाओ ना कहाँ है बुके कहाँ है अशोक पांडे आप बुके दीजिए बुके कहाँ है रेडी है मंगाइए ना हाँ अनाउंस कर दें आप करेंगे अनाउंस आप करिए चलिए
Hello. So good evening. After a hectic day, this is the sixth working session. Last session you have attended. So our most important judges of Supreme Court, your so popular judge, Justice Vishwanathan, K.V. Vishwanathan is here. Justice Manmohan, Delhi High Court, Justice Suman, Shyam, Gauhati High Court, they are here. And Speaker already, my friend Rajpath Sharma has already informed me about Vikramjit, Banerjee and Saikrishna, Rajagopal. So now I would like to request our friends to give bouquet to Honorable Justice K.V. Vishwanathan, along with one shawl and memento. Rajpath Sharma. Mr. Shailendu is not there, no?
Thank you very much.
Next, my Lord Justice Manmohan, Delhi High Court Judge, he will be felicitated by, yes, Subir Sidhu, former Chairman, Punjab and Haryana High Court. He was the youngest Chairman, Punjab and Haryana Bar Council. Next, I'd like to request Chinmay Chaudhary, Chairman, Bar Council of Assam, Nagaland, etc. He is here. He will felicitate Justice Suman Shyam, most popular judge of Gauhati High Court. Next, Mr. Vikramjit Banerjee, Additional Solicitor General of India. He will be felicitated by Mr. G.N. Sahewala, former Chairman, Senior Advocate, former Chairman, Bar Council of Assam, Nagaland, etc. I would like to request Mr. Prasant Kumar Singh, Member, Bar Council of India from Jharkhand. He will felicitate Saikrishna Rajagopal. Interestingly, here Vikramjit Banerjee and Saikrishna Rajagopal both are from National Law School, Bangalore. So now I would like to request our Chairman of this session, Justice K.V. Vishwanathan, to say a few words.
Thank you, Mr. Apurva Sharma. My fellow panelists on the chair, Justice Manmohan, Justice Suman Shyam, Additional Solicitor General Vikramjit, Banerjee, and Saikrishna, distinguished members of the audience, very happy to see a young audience predominate this session, because this is a topic which I think is not only the future, it is also something which all of you can easily adapt, because I find that with your generation, with all this digital and other things, the receptivity is of a very high order. Now, the arrangement that we have had informally is that each of us will give an opening between 8 to 10 minutes, and then, of course, Sai and Vikramjit will take questions from the audience. So with that background, friends, welcome to Technical Session 6, Intellectual Property Rights in a Borderless World. According to me, not because I am chairing it, and I know that there are panelists from other session here, they must have said it for their session too, it is without doubt one of the most significant issues that are being discussed, and I congratulate the Bar Council of India for including this. And I think by and large in the inaugural, in the initial meetings we had, we must thank Justice Manmohan for suggesting this topic and giving it a shape. The morning's inaugural session and the words of the Chief Justice of India, Dr. Justice Chandrachud, set the trend for today's session. He said the vast challenges thrown by technology in the area of IP. Now, it is up to the legal fraternity, he said, to navigate the landscape. Now, what is this landscape looking like, and what methods of navigation would be most suited are some of the questions that arise. So we'll briefly see what are the challenges. And the most fascinating, I have got some subtopics, but there'll be others who will be handling it in greater detail, I find is the challenge thrown by artificial intelligence. And that is because I came across a recent book, which most of you also must have come across, Henry Kissinger's Age of the Artificial Intelligence. And there is, in page 10, a fascinating discovery of halicin, an antibiotic at the Massachusetts Institute of Technology. And why is it significant? The Massachusetts Institute of Technology, when they set out to invent an antibiotic to tackle a particular bacteria which was eluding a cure, they invited artificial intelligence to participate in the process. Researchers developed a training set. We'll come to the legal issues that will arise, because if you see what has happened here, it throws up some fascinating legal challenges. The training set encoded data about each, ranging from its atomic weight to the types of bonds it contains to its ability to inhibit bacterial growth, etc., etc. Ultimately, about 61,000 molecules in the library were identified. Not only molecules, the FDA approved drugs and the natural products for molecules that AI predicted would be effective as antibiotics did not look like any existing antibiotic, and the AI predicted would be non-toxic. Of the 61,000, one molecule fit the criteria, and they called it halicin. Now, what does it signify? It appears that an natural manual research would have been prohibitively expensive, which means it would never have happened. And they say that beyond a process, because it was AI, it was not even known. There is no rational method of explaining how it arrived at that particular bacteria. I mean, that particular molecule to cure the bacteria as an antibiotic. Now, the questions that this would throw up for a common man is, who is the inventor? Is it the data provider, the AI module developer, who is the owner? And how does the definition of a person skilled in the art change due to AI tools becoming? And to what extent the use of AI will be permitted while you register a patent. There is some guideline we came across in our research about the US Patent Office, in terms of copyright here, permitting AI as long as it is de minimis. In a case called Theatre d'Opera Special, copyright was denied because the work contained more than a de minimis amount of AI-generated content. And Allen, who sought copyright, actions as described do not make him the author because of the role that AI had played in the process. Now, this is one aspect of the matter which you will elaborate. The common example that is now in the limelight is of the patent application of Stephen Taylor. Stephen Taylor invented an AI machine known as Dabus, device for autonomous bootstrapping of unified sentience. And it appears while South Africa granted him the patent, Germany, Australia, and many other countries have refused to grant it. Now, this is as far as AI in medicine is concerned. Now, what happens in Chat GPT and what is called generative artificial intelligence? Generative artificial intelligence is artificial intelligence capable of generating text, images, or other media using generative models. Now, the problem is, does copyright, patent, trademark infringement apply to AI creations? And if there is a violation, how do you enforce? How do you regulate this sector? A couple of solutions on offer. Could the input data be licensed? Because when you generate GPT, a lot of data goes in. Or could there be a situation like an IPRS where the owner grants it and then, license is where authors could give their creations in return for a monthly fee, and generative AI can access these credible databases for a subscription fee. One could think of it, because issues of liability will arise, and is the creator of an AI platform to be held responsible, or the user who utilizes it, is he to be made responsible? Who is the owner of the content that generative AI platforms create for you, etc., etc. Most fascinating aspect that I found in the survey that we briefly did is the aspect of the standard and essential patent litigation. I told Justice Manmohan that I would not steal his thunder. No. He has had occasion to pronounce very erudite judgments. I want to openly compliment him on that. But there was one aspect of FRAN which I also told you that I want to highlight. Now, just for an introduction before I get to what Robin Jacob, the prominent judge in UK who went on to teach intellectual property, the thought that he leaves on FRAN, which I want to share with you. Unlike traditional proceedings for infringement of intellectual property rights, which are normally focused in one jurisdiction, standard essential patent litigation is characterized by multiple proceedings in multiple jurisdictions by the same parties. These proceedings involves determination of fair, reasonable, and non-discriminatory, which have come to be known by the famous acronym FRAN, royalty rate, with respect to a global portfolio of patents, notwithstanding that some or most of the patents were not even registered in the country in which the patents are sought to be enforced. These are standard patents which you have to license, because without this, the product cannot function. That part Justice Manmohan will explain, apart from the other aspects which he wants to discuss. But now what happens is, if there is somebody who wants to violate and forces the patent holder to initiate a litigation, he violates it, there is an injunction proceeding initiated by the patent holder. He might, that as a defendant, sue for revocation of patent, might not sue, but he delays the process. Nor does he participate, because Justice Robin Jacob says, and Justice Manmohan also elucidates, because he has nothing to lose. He will hold on to the litigation, and then at the end of it say, all right, if I lose, I now take at the rate that you have offered others. What Justice Jacob says is, and I will read this for you because this is something which one needs to think about to mold the relief, so that frivolous litigations are dissuaded. And I found it most appealing, so I will put it before you. What if the defendant says that the patents sued upon are invalid or he is not using any of them? Firstly, he is and must be at liberty so to contend. I side with competition law and public policy in saying that anyone must be at liberty to apply to revoke a patent. Resolving these issues will take time. Court may be asked to grant an interim injunction meantime. If it is so asked, then the sensible way forward is to put in place an interim regime as above, undisputed amount you pay, remaining bank guarantee or escrow. Those are all interim arrangements. But what Justice Jacob contemplates and he suggests for the future is, if the defendant wins the patent dispute, that is the end of the matter, no problem. What if he loses? Can he just take the patentee's original offer or content in the FRAN dispute that he should pay the same as if he has not challenged the patent? Then what is the disincentive to not litigate? There are two very, very plausible suggestions. How far a court of law would accept it is we have to wait and see. Jacob says no for two good reasons. Firstly, as a matter of business sense, a patent of established validity, now that it has gone through the test of fire and it is held out as a valid patent, very often there will be a challenge of revocation. It has failed or there has been no challenge. It has now come out of the test of fire and it is now a patent, if it is a patent of, first as a matter of business sense, a patent of established validity is worth more than one which has not been challenged. Any realistic notional negotiation for a license will take into account the likelihood of the patent being held valid, so he's slowly upping the value now. Then what does he say for the man who dragged them to the litigation? Secondly, there is the patentee's FRAN commitment itself to consider. In particular, it will very probably have other licensees that have accepted its offer of a license. They did not challenge the validity, so they are in a group. He has challenged the validity, he has dragged them to court. It would be wrong, he says, discriminatory to treat the party that unsuccessfully challenged as if it had not. He says it would be discriminatory to give him the same rates. So the patentee is indeed obliged by its FRAN commitment to charge the unsuccessful challenger more. This is the solution which is offered, and why? The good thing, it encourages third parties to consider carefully before challenging validity and thus prevents spurious litigation and reverse hold-up. Because the idea is if a patent holder doesn't license, he is holding it in. If by letting a frivolous challenge, he is again having what he calls a reverse hold-up. So to disincentivize frivolous litigation, he suggests this method, and I want you to seriously consider and debate this. But now quickly, I know that there are 4 more eminent speakers to follow. The aspect of a dynamic injunction, which is now, lastly reiterated by Justice Pratibha Singh, Justice Manmohan said he would elucidate on that, where, various websites, even if you, take them down, through private networks, they, again pirate the whole thing. So dynamic plus injunction is given where all these spurious websites which come for future are, on an affidavit injuncted from resorting to it. There have been recent pronouncement on key search AdWords and on meta tags. I'm sure Sai would elaborate on that, but I found that one area where some standard norms would be required is to decide if the normal confusion and deception test of an average intelligence man is not to be applied on the internet, what would be the test which would apply by and large to all standards of familiarity? Then you have the famous metaverse. Justice Suman Shyam would deal with it. I would only want to touch upon one aspect of it, an interesting case where Hermes, the producers of the Birkin's bag, in the late 2021, protested the sale of Meta Birkins via non-fungible tokens sold on OpenSea, created by artist Mason Rothschild, and succeeded in getting an injunction. Today, the Nice Convention, subject to correction, doesn't, as of now, it is expected that in January 2024, they might come out with, virtual goods and recognize them. But till that happens, what should be the regulatory regime that would regulate it, and the aspects with regard to AI, etc. I would want other speakers to elucidate. I want the younger members to participate and ask them questions, because we have this, judges, we can't be expected to answer or take a stand. But I think it is a fascinating topic, whichever way you look at it. We have a very eminent panel here. Manmohan, who has heard cases and pronounced on it. This is Suman, Shyam, who is itching to go ahead with his non-fungible tokens and the regulatory regime. Vikramjit, Banerjee, always silent, but tremendous things to offer. And Saikrishna, who's practicing in this and domain expert in his own right. Thank you so much. And with this, I think we are in for a virtual treat. All the best to you, and good evening once again. Thank you. May I now request Justice Manmohan to give it.
Respected Justice Vishwanathan, Justice Suman Shyam, Mr. Vikramjit Banerjee, Mr. Saikrishna. We all know that law always lags behind technology. But today, there has been so much of advancement in science and technology that certain basic concepts of law that we grew up with are under challenge. For instance, property laws or intellectual property laws have always been considered territorial. In the sense, the law or the principles of law will not be common if you jump jurisdiction. But in today's world of metaverse, of internet, or the digital assets, this concept itself has come under severe strain. In fact, today, enforcement of court orders, as well as intellectual property rights which an owner may have by virtue of registration, is also posing to be a great challenge. In this seamless world that we are operating in, where at a click of a button, I sitting in Delhi can buy something which has been manufactured in New York, the jurisdiction issue is a major issue that is arising today. And implementation of court orders is a very big challenge. For instance, today you find that there are many violators of trademarks, of copyright, of patent law, who are operating from scofflaw nations, as we call them, where the law just doesn't exist. And how do you deal with that situation where the source of infringement or the source of violation is based in that country? If you can't tackle the source, how will you deal with it in this seamless digital world that we are in? So I will try to convey the significance of this topic, and I must confess that I had suggested this topic in the initial meeting, and that is the intellectual property rights in a borderless world. Because the moment a person jumps jurisdiction, it becomes impossible to implement someone's right and the court order. And I will illustrate this by referring to two industries and a concept of law. Let's take the case of the entertainment industry. See, when we were young children, we used to go and watch a movie. There used to be one print of that movie which used to be made. And to be a hit, it had to run at least for 25 weeks. Now no film runs for 25 weeks because there are so many prints that are available. Those are the digital prints that are available. But digital prints have given large viewership, but they have also ensured that there is large amount of piracy. See, in the mid-80s to about 2000, the entertainment industry was, the Hindi film industry was virtually in the dumps because of piracy. Whatever was being made was getting pirated initially in the form of video cassettes and then in the form of infringing websites uploading it. What was the response of the courts? The courts passed injunction orders against the infringers, but at that time most of the infringers or infringing websites were based in India. So you could deal with the source of the infringement. Today, things are very different. The pirated film may be uploaded on a server based in a country with whom we have no diplomatic relations. That may be a country which may be at the moment going through a phase of anarchy. Now, if from there a server is uploading a film on the YouTube, how do you deal with it? So this was a problem which is occurring, and the court was passing injunctions. Say, torrent website is there, and it's actually a case which Mr. Saikrishna filed when I was a judge, and I was hearing it for Universal Studios. And he said, you know, I have to come to court every day. I get an injunction against torrent. The next day, they open another website called Torrent 1. And all the hits which are there for torrent get diverted to Torrent 1. Then he says, I take an injunction against Torrent 1. It becomes Torrent 2 tomorrow. Or it becomes Torrent A. Or it becomes Torrent B. How many suits am I expected to file? My client can't do this. And it's so cumbersome, it's so expensive. So we had to find a solution to the problem. And the solution that I hit upon after speaking to the amicus and after hearing him at length was that we must have a dynamic injunction. What is that dynamic injunction that we thought of? The dynamic injunction was that you will first have to establish in the suit that the website which you complain is the infringing website is a rogue website. It is what is known in law in some jurisdiction as FIOL, F-I-O-L, flagrantly infringing online location. For that, we laid down a non-exhaustive test. Primarily, the test was, have previous injunction orders be passed against that against this infringing website? Has this infringing website not appeared in those suits? Then, what is the who-is detail of that infringing website? Who-is detail is, when you go for a registration abroad, you have to give the details or the particulars of the owner of the website. Suppose it says Torrent Bay based in, say, some Cyprus island, and it doesn't have a proper address, it doesn't give any apartment number, doesn't mention anything, just mentions www.sealink.com, something like this, so that tomorrow he can disappear in case you send him a message. These are the telltale signs where you will recognize it as a rogue website or a infringing website. And if the plaintiff gives you an instance that this is a rogue website, that means you pass an injunction order against Torrent Bay, it becomes tomorrow Torrent Bay A. This is something known as a hydra-headed monster in Greek mythology. Hydra-headed monster means that you chop off the devil's one head and two heads crop up. So how do you deal with that situation? So we said, you get it declared as a rogue website, get it declared as a flagrantly infringing online location, injunction will be passed, then all those alphanumeric or mirror websites, as we call them, Torrent Bay A, B, X, Y, you just file an application before the joint registrar, and injunction will automatically follow against those entities. And the Ministry of Information and Technology will issue an order to the ISPs saying block the website with all its alphanumeric mirror images, and that website will get blocked. Then an issue arose because I had said that you have to move an application, but we shall not be listed before court, but before the joint registrar, and an injunction will follow for the ASGI. Then an issue arose in IPL matches. It's 20 over matches. Now, when infringement takes place of them, the code is not even working because the IPL matches take place in the evening. He does not even have a time to approach the joint registrar for moving an application for implementation. So how do you deal with that situation? Then the court again improvised. The court said, you need not file an application. You straight away inform the ministry that this is happening, and within a few minutes they'll pass a direction to the ISP and close those infringing websites, or what I would call is create an island by ensuring that those injunction orders are passed and those websites cannot be accessed. Then what Justice Vishwanathan referred to is the further improvement that has now taken place, because what was happening was that if Universal Studio filed a suit today, it did it with regard to the film that had been released today. What happens next Friday when his new movie comes? He has to file a new suit. So that is the dynamic injunction plus which has now happened. So Universal Studio has filed a first suit with regard to A film. When his B or C film comes, he does not have to file a fresh suit. In that previous suit, he will just add the name by way of an amendment application, bring in the name of that B movie also and the C movie also that will be released. So he doesn't have to pay court fees, and the injunction will follow against those notorious websites which have already been injuncted. Alphanumeric mirror websites, as we call them. So this is the borderless world that we are dealing with and how the courts are trying to adapt with it. Then Justice Vishwanathan referred to the standard essential patents matter. That's again a fascinating genre of litigation that has emerged. See, we all carry mobile handsets with us. You know, I was shocked to learn that in each mobile handset, there are something like 3,000 to 4,000 patents. It doesn't have a single patent. It has 4,000 to 3,000 patents. Various types of patents. Voice telephony, noise cancellation. All these are patents which are there. Now, this mobile handset, which I may buy in India, I may use it when I travel to New York, when I travel to Cape Town, when I travel to Sydney. These mobile handsets are supposed to work in all jurisdictions. And if I buy an Apple handset, the call from there must go to the Samsung handset. So all of them have to be at par with regard to the patents, in the sense the technology has to be similar if not identical. So they all have to use similar patents. That's why there is a small genre or species of patents which we call standard essential patents. These are those standard essential patents which permit interoperability. Today, one of the key things in patent law is the instrument must be interoperable, not only in India, but in all jurisdictions, and it must be that the industry adopts it as a norm. Therefore, this is known as standard essential patents. Now, when I travel with my handset to all the jurisdictions, and if the allegation of the inventor is that the implementer, that is Apple, is not paying him for a particular patent, where does he file that suit? Since the phone, this mobile handset is traveling all over the world, and you may buy the handset in India, I may buy it in Singapore, the jurisdiction is available all over the world. He may, so the implementer doesn't know where the suit is going to come. If the Chinese handset has been purchased, say, in Germany, the suit could be filed in Germany. If it has been purchased in India, it could be filed in India. So then the innovator decides where to bring that suit. And that is creating its own complications. Now, if there is an instance of infringement, most of these inventors are basically Swedish or Finnish firms. The patents are being devised by Ericsson, Nokia, And these handsets are basically from Apple and say Samsung. Now, or the Chinese firms. So if there is a violation, they file a suit for injunction. They can file it in India. They may get an injunction, but they may go to another country and they may not get an injunction because someone may declare their patents not to be valid. So how are you going to deal with this conflicts of orders, of jurisdictions that are arising in this world? Some courts, I must tell you that when such infringement matters are filed in standard essential patents, have a different approach. Some grant injunctions, some say we don't grant ex parte injunctions. Some will say we'll grant ad interim after hearing the other side. Some may say as a policy we don't grant injunctions at all. We will set the matter for final hearing next month. You complete the pleadings and we'll hear you. So when there are different approaches of different courts, because they are guided by their own laws, how do you deal with that situation? Now, if Ericsson were to sue a Chinese firm in Delhi and get an injunction, it is not necessarily that a similar injunction would follow in Germany. The German court may have a different view to take. So this is leading to some sort of a conflict in orders, and there is no uniformity. There is no predictability. Let's take another genre, and that's what I said. I'll refer to two industries. I have referred to the entertainment and the telecom industry, and now I'm referring to a concept of law. I don't want to take too much of time. The other speakers are also there. That's the anti-suit injunction that we have. Anti-suit injunction basically means that a party can take an injunction order against the defendant saying do not prosecute a suit or do not file a suit in a foreign court, because that proceeding will be oppressive and vexatious. Courts, if they find that the proceedings to be launched or already launched in the foreign court are going to be oppressive and vexatious, can stay them under an anti-suit injunction, and the anti-suit injunction is operative against the defendant, saying you will not proceed ahead with the matter. Now, again, I'll refer to the patents case. There was a Chinese firm, and that's actually a reported decision of this of the Delhi High Court, between a Chinese firm who was the implementer and IDC, I think it's a Canadian company. It was the innovator. So the Chinese firm filed a suit in China, in Wuhan, and said, yes, we are using the patents of this Canadian company called IDC. We do not have a license. We have to pay them. And what Justice Vishwanathan referred to was the friend rates. At what rate should this license be given? Friend means, as Justice Vishwanathan pointed out, that it is fair, it is reasonable, and it is non-discriminatory. And in standard essential patents, the obligation cast on the innovator is that he has to give this technology or this patent to everyone who asks for it. He can't deny it, because if he were to deny it, as I told you, there will be no interoperability. If you deny it, the industry will not be able to function. How will the call go from one phone to the other phone? Therefore, he has to give it. The only question is at what rate. And the rate has to be fair and reasonable. It's not that it will be uniform rate. It can be a different rate for different people. It can depend, for instance, if Apple is a huge consumer, say he's going to buy 25 lakh patents, you'll surely give him a discount rather than a Chinese firm who's going to buy 1 lakh phones. So this sort of he filed a suit. The Chinese firm filed a suit in Wuhan and said, please fix my friend rate. The Canadian company felt that its patents were being infringed. So it brought a proceeding in Delhi High Court and said infringement is taking place of my patents in India also, because the Chinese handsets are being sold in India. Court granted an injunction. So the Chinese entity, that is Shumi, filed an anti-suit injunction in the Wuhan court and said, please injunct IDC from proceeding ahead with its suit in India, in Delhi High Court. And the Chinese court granted that anti-suit injunction, saying, once I am determining the friend rate, where is the question of you taking an injunction with regard to infringement? And it said that if IDC proceeds ahead with the suit, it will pay a fine of 1 million, it's called renminbi, that's the Chinese currency, per day. So the Canadian entity, which was the innovators, approached the Delhi High Court and said, please grant me an anti-suit injunction. Please prevent him from prosecuting ahead with the Chinese suit and restrain that court from proceeding ahead. So Delhi High Court said that if some person is trying to establish his rights with regard to infringement, which is his statutory right, then the proceeding in China is vexatious, is oppressive. The test of an anti-suit injunction is satisfied, and therefore it granted an anti-suit injunction. This is the conflict in this borderless world. Which court will have jurisdiction and which court will take precedence? This is a very important conflict in today's time in this borderless world. See, multinational corporations and corporations which work across jurisdictions don't know what the law is. They require certainty, they require predictability, they require uniformity. They require, as I said, certainty, consistency also. Without that, no one can do business. Therefore, this borderless world has a lot of challenges for us. The question is, where do we find the solution? Because territorial laws are under severe strain and under severe challenge. A possible way forward, to my mind, is what we have done with regard to arbitration law. We had a unilateral convention, and it prepared a draft model law, or the New York Convention with regard to the foreign arbitration awards. They prepared a convention. The basic outline or the norms are settled, and each and every country can, within the four corners of that law, adapt, modify the domestic law. But the basic principles, the basic norms have to be agreed upon. The advantage of adopting this model law is, as I said, that the countries are free to adopt. They can adapt it, they can keep in view their domestic legal principles, public policy and industry concerns. But it has its disadvantages, as preparing a model law is a difficult exercise, particularly when the needs, aspirations and availability of technology is not uniform. In conclusion, I would like to say that IP rights are the bedrock of innovation and creativity. Let us remember that IP law is not just about maximizing profits, but they are about incentivizing innovation and creativity and advancing human knowledge. The borderless world certainly presents a large number of challenges to us, but it also offers us unique opportunities to build a future where innovation knows no bounds. Thank you very much.
Thank you, Justice Manmohan. That was an enriching address, and your ultimate conclusion that perhaps international convention where all of them, come together and decide on certain common norms, like we have the New York Convention for recognizing foreign awards. Some such thing will be the ultimate solution. May I with that invite Justice Suman Shyam, who has come all the way from Gauhati, distinguished judge at the High Court at Gauhati, to present his views in the matter. Thank you.
Honorable Justice K.V. Vishwanathan, the chair in today's session, my esteemed colleague Justice Manmohan, Mr. Vikramjit Banerjee, ASGI and Senior Advocate, Mr. Saikrishna, Senior Advocate, who is one of the panelists here, the learned members of the Bar and the Bar Council of India. Good to see some faces from back home who have traveled all the way to attend this function. My dear students present here in good numbers, ladies and gentlemen, a very good evening to all of you. In the beginning, the Honorable Chairman has kind of given me a mandate, or rather accepted a request from me that I wouldn't like to be too broad because of time constraints and the technical nature of this subject. So I will try to confine my speech into a particular area, which is digital assets and the underlying IPR issues. But since there are quite a few students present here, let me begin with an observation which is slightly more elementary. So, as you all know, with the increase in cross-border trade and commerce, the need for heightened protection of intellectual property is rapidly gaining significance. In the recent times, these issues pertaining to IPR rights violation and protection have found mention in various international dialogues and discussions which preceded drawing up of bilateral agreement of trade and commerce between the countries. From the Indian perspective, the legal regime on IPR is basically governed by the 7 statutes, which you would be aware: the Copyright Act of 1956, the Trademark Act of 1999, Patents Act of 1970, the Designs Act of 2000, the Protection of Plant Varieties and Farmers' Right Act of 2001, the Geographical Indications of Goods Registration and Protection Act 1999, and the Semiconductor Integrated Circuit Layout Design Act of 2000. However, the Copyrights Act, the Patents Act and the Trademarks Act continues to be the main pillars of the copyright law in India. If you look at it from this angle, the Patents Act actually protects an idea or invention. The Copyright Act protects the expression, and the Trademark Act protects the sign or the figurative mark of a company's product to protect the brand. Therefore, these are the 3 fundamental elements which are very well taken care of or guarded by these 3 statutes operational in India. And the primary object is obviously to prevent and protect from counterfeiting and piracy. Now, in this era when cross-border trade and commerce is growing in a big manner in leaps and bounds, and we are having myriads of challenges coming from the internet world, I think this is a very nice topic to discuss on in this session. Therefore, I'll congratulate the Bar Council of India for holding this conference and also choosing, and Ms. Justice Manmohan particularly for suggesting this topic. A big hand for him. Now, coming to the digital assets, as you will be aware, digital asset is, even today, particularly in India, it's a very amorphous entity. Normally, things like cryptocurrencies, NFTs are referred to as digital assets. Now, in India, we do not have any statute which defines digital assets, but recently by amending the Income Tax Act by the Finance Act of 2022, virtual digital assets have been introduced for the purpose of taxing, and some amendments have been carried out in some other statutes such as PMLA, etc., giving the power of seizure and attachment of virtual digital assets, which includes cryptocurrencies, etc. Now, we are not concerned with cryptocurrencies here because cryptocurrencies are protected by fungible tokens, which can be minted. But NFTs are protected by non-fungible tokens, which cannot be minted, or rather, it cannot be replicated. It gives a unique certification. Now, I would here like to start with a disclaimer that as judges or courts of law, we are expected to be technology neutral. We are expected to decide issues, rights, liabilities, and disabilities based on the facts and the evidence that is produced before the court. But in case of digital assets, which actually exist in technology, it is possible that many issues involving rights, liabilities, and disabilities might actually percolate into the technology. Therefore, please pardon me if I go a little into the technology so that one has an idea about what exactly are we confronted with. In fact, while dealing with these virtual digital assets, the Honorable Supreme Court of India has recently delivered a judgment, which you will be aware, Indian Mobile Owners Association and others, where some circulars of the RBI were put under challenge. So Justice V. Ramasubramaniam, who was the author of the judgment, as his lordship was then, had used an Indian philosophical expression to describe what exactly these digital assets or cryptocurrencies or virtual currencies could be. His lordship has mentioned and referred to the concept of neti in the Vedic analysis to say that this is an expression of something inexpressible, but which seeks to capture the essence of that to which no other definition applies. So therefore, you can have an idea of how difficult it is to have an idea of digital assets and the various features of it. But let me talk about some of the issues related to non-fungible tokens as digital assets. Now, as is commonly known, digital assets are stored in technology known as blockchain technology, which can be viewed as a ledger-based system which offers a unique combination as cryptography and a distributed peer-to-peer network of nodes which allows tamper-resistant, append-only and immutable ledger that can maintain confirmed and validated data in a trusted key system. Sounds very technical, isn't it? Maybe I'll try to give you a little clarity on what exactly these things mean a little later. Now, digital assets are stored in blockchain which contains information that is considered as valuable data stroke database, which can include images or textual expressions, and the information is subject to applicable intellectual property rights. However, the information existing outside the digital assets is not to be considered as a part of the asset. If the information included in the digital asset is itself subject to protection under the intellectual property, presumably the copyright law, the rights of the holders of intellectual property would be preserved notwithstanding the inclusion of the information in the electronic record or the transfer of the digital assets. Non-fungible tokens are areas where, as Justice Manmohan has mentioned, there are already litigations in the Delhi High Court. I believe recently there was some IPL, yes, some cricket players representation were there. Now, NFTs are also blockchain-based tokens that represent a unique digital content, such as a piece of art, and are treated as irrevocable digital certificates of ownership of the digital asset, if tokenized. In the month of July 2022, there was a very interesting case which went to the court in Italy, in Rome. That was when the Juventus Football Club I believe there are many football lovers here who will know about the Juventus Football Club, went to the court suing the defendant on the ground that the important trademark Juve, which is called colloquially and which is referred to as Juventus, and the figurative mark consisting of the black and white striped shirt and the 2-star on the chest had approached the court in Rome, Italy, raising a dispute concerning trademark infringement and unfair competition practices consisting the unauthorized use of the aforesaid word and figurative marks to the production, marketing and online promotion of digital playing cards NFTs, reproducing the distinctive sign insofar as they show the image of a former player of the club. His name was Christian Boboveri, wearing the Juventus shirt and the name of the team. Now, this is a case where it appears that Boboveri had actually given his consent to the NFT producer to use those symbols. The court in Rome held that the circumstances that the Boboveri actually played for the club and he had granted permission to the use of this image through the creation of the cards by reproducing a player with different shirt of the team did not exclude the need to request authorization for using the registered trademark owned by the team whose shirts and names were reproduced. It was held that the goods producing such trademarks were indeed intended for sale, and the reputation of various teams where the player played also contributed towards the value of the digital image offered for sale. It was thus concluded that the creation and making of the cards constitute infringement of trademarks, giving rise to likelihood of confusion due to the identity of the signs used, in a way misleading the public as to the existence of a commercial relationship between the defendant and Juventus. This was the first decision of the courts in Europe involving trademarks infringement through NFTs, distinguishing between the digital content reproducing the trademark and the digital certificate thereunder. It was observed by the court that NFTs had their own legal status and should be assessed independent of their content. Now, Justice Vishwanathan has mentioned about the Birkin's bag case. That was a case where the artist had actually floated an NFT level called Meta Birkins and had also come up with his website called metabirkins.com, and the brand had sued the defendant. Ultimately, the company had succeeded. It was a case in Hermes International and Hermes of Paris Incorporated versus Mason Rothschild. There, the court was called upon to decide as to whether the digital images underlying the NFTs produced and sold by the artist depicting fur-covered Birkin bags infringed and or diluted the plaintiff's trademark pertaining to his Birkin handbags. Now, I would briefly like to talk about the generative artificial intelligence and its impact on the intellectual property right issues. The recent developments in the field of artificial intelligence and the emergence of chatbots have in a way democratized the use and access of artificial intelligence to generate creative work. These new technologies bring a string of copyright questions and challenges. The work generated by the use of AI has raised serious questions as regards ownership of the same and also on the question of enforcement of intellectual property rights. Generative AIs can be used to create unique NFT art, but instead of tools like brushes, paints, or even digital illustration softwares, words and prompts are used to do so. Once the art is ready, one can not only showcase it worldwide, but even sell it. Thus, an art piece tokenized through NFT assumes the character of property of its creator. Now, the property question of NFTs and digital assets is again a very big question. In India, perhaps we do not have any judgment of any court so far. But I would only like to mention here that by relying upon the 4 indicators evolved in the case of National Provincial Bank versus Ainsworth in 1965 by Lord Wilberforce, where 4 indicators for identifying a property was evolved, which are commonly known as Ainsworth indicia. The courts in England and Wales have gone on to hold that crypto assets are actually properties by adopting the principles of things in action and things in possession. There is a judgment of 2019, AA versus Unknown, where it was held while granting a proprietary injunction in case of cryptocurrencies, that these are to be treated as properties. And by following this judgment, the courts in Singapore, in a recent judgment, Janesh versus Unknown, the Singapore court has also granted proprietary injunction in case of violation of NFT right. But the notable feature is that the Law Commission of United Kingdoms has recently submitted a paper based on the opinions received on the consultations that took place on digital assets, and have advocated that digital assets should be created as a third kind of property, as data object, and has also suggested some new indicia to identify digital assets. There is a recommendation made to the Crown to come up with legislations for that. One has to wait and see. This recommendation has come only in the month of June 2023. But if this recommendation is accepted and legislations do come up, then undoubtedly it will have a huge impact on the decisions of the courts of England and Wales, which were very positive on and flexible on the definition of properties while dealing with digital assets. But we'll not go deep into it. The Copyright Act in US protects original work of authorship. However, to qualify as an author, the US law requires that the work must be created by a human being. US patent also expressly provides that inventions must be by individuals. The Court of Appeal in UK was of the view that UK Patents Act 1977 also proceeds on the basis that an inventor would be a natural person. Section 3 of the UK Patents Act 1977 says that an inventor in relation to an invention means the actual deviser of the invention, and joint inventor shall be construed accordingly. Again, as per Section 3 of the UK Copyright Design and Patents Act of 1988, in the case of literary, dramatic, musical or artistic work which is computer generated, the author shall be taken to be the person by whom the arrangements necessary for the creation of the work are undertaken. Now, what I mean to show is that these important statutes of these countries have made it clear that work generated purely by computers cannot be accepted for granting patents and copyrights. In fact, the patent offices of Europe, Japan, China, South Korea, Australia and New Zealand have also taken similar positions, that the term inventor must refer to a natural person. Perhaps it is for this reason where it was mentioned that Stephen Taylor's case. These countries have declined patents to the scientist Stephen Taylor, whereas South Africa actually took a slightly different view. The position, I would say, is more or less very clear in India as well, where Section 3 of the Patents Act 1970 expressly excludes computer program per se or algorithms from the category of inventor. In fact, Section 2, subsection D6 of the Copyright Act 1957 also refers to a person who causes the work to be created as the author in relation to literary, dramatic, musical, or artistic work. Now, as I have already indicated, in the case of Stephen Thaler versus Catherine K. Vidal, the US Court of Appeal has held that with the passage of Leigh-Smith America Invents Act, an inventor under the US Patent Act has been defined as the individual, or if a joint invention, the individuals collectively who have invented or discovered the subject matter of invention. Now, the courts in USA has been consistently ruling that creation by AI without human input cannot be copyrighted under the US law. The conflict between the technology and law on these particular aspects came to the fore in India also very recently, when the Copyright Office had registered the work of art called Suryast. I don't know how many of you present here are aware about it. Suryast was a work of art created by an AI system called Raghav Artificial Painting App. This was listed as a co-author with the owner of the app, whose name is Mr. Ankit Sahni. So patent was granted, but interestingly, this same app had filed an application earlier seeking patent as the co-author. Then it was rejected. So these are perhaps very nuanced areas of this particular legal regime, which will come up before the courts in the days ahead for a decision. But for now, there appears to be no clarity on these matters, where even artificial intelligence as a co-author to a particular creation has been granted patent, copyright by the Copyright Office. Another question I would now like to find, another question that would arise in the realm of copyright law is as to whether text images protected by the copyright law, when using as training data for AI applications, would infringe the right of thousands of authors and artists on the internet. The recent developments in the field of artificial intelligence and machine learning, particularly with the emergence of generative tools such as ChatGPT and Mid-Journey AI apps, has made this question very relevant and significant. Training AI models on copyrighted data would likely be considered fair use, but the same cannot necessarily apply to generating content. To put it more clearly, one can perhaps utilize someone else's data in order to train the generative AI model. However, what would ultimately be done with the generative output of this model might have infringing effect on the copyright law. In fact, some of you present here might be aware, only 3-4 days back, that is on 20th of September, as many as 17 authors, including novelist of the repute of John Grisham, have filed suit against the OpenAI, which is the owner of chatbot, in the court in New York, suing for compensation by alleging that the data used by this OpenAI chatbot to train the AI is nothing but a systematic theft of mass scale. It will be interesting to see how the court deals with this, but these are certainly issues which will confront our society in days ahead. Realizing the importance of artificial intelligence, which can play in the copyright issues, even the United States of America recently had carried out a policy study on impact of AI system, and have invited comments and views from various, including those involved in the use of copyright works to train AI models. The Parliamentary Standing Committee report on the IPR regime submitted on 23rd of July 2021 has also highlighted the relevance and utility of cutting-edge technologies such as artificial intelligence and machine learning, and has recommended that a separate category of right for AI and AI-related inventions and solutions be created for this protection as IPR. There is another important area of protection for these digital assets, is the rule of innocent acquisition, which is based on Principle 8 of the Ian Wright recommendation, which I will not go into because I have already exceeded my time. Suffice it to mention that these are very, very challenging areas which are going to soon confront the court of law, and therefore we have to think as to how to deal with these things. Before concluding, I would like to thank the organizers for giving me this opportunity to be a part of this session. Thank you and Jai Hind.
Thank you. Thank you, Justice Suman Shyam, for elucidating the abstract concepts in very simple and plain language. Now, may I request Sir Vikramjit Banerjee, Additional Solicitor General of India, give his views on the matter.
Thank you, Honorable Justice Vishwanathan, Honorable Justice Manmohan, Justice Shyam, my good friend Sai, and everyone else who's present here, including a lot of my friends whom I know from the bar. And thank you for the Bar Council for giving me this opportunity to speak. Now, I have seen these wonderful, erudite, very detailed presentations of the honorable judges, and it's extremely erudite and very detailed. But my presentation is going to be more on what I consider the policy issues and the future challenges of IP in the borderless world that is on us right now. Okay, so that is how I would like to take off on the point that globalization and technology have been the two factors which has completely disrupted the IP regime as we see it today. When we grew up in the 90s, post-liberalization, we grew up in a different world where the mantra was that growth was based on intellectual property, and it is intellectual property which is going to drive in future all the benefits which are going to accrue in society. So it is going to be the driver of bounty. But we've seen how the dreams which we had in our 90s when I went to law school have played out in the world. And it's not, according to me, as an outsider and as a commentator and as an observer of the subject with keen interest, that it hasn't panned out in the way we thought it would. It hasn't benefited everyone. So the whole question which I would like to put forward, and this is a great time to do that, is that do we need to relook at the regime itself? And of course, there needs to be concentration on specific areas, and it's interesting. That's what it should be. But it also, I would take the opportunity of this discussion to put forward that maybe we need a detailed, much more detailed look at it. Maybe we need to look at some of the ideas and turn them around on their head. Now, before we start, and some of the areas which have been discussed, and some of the areas which are obviously the topic of discussion, is the question of technology and digitization. One is, of course, the issue of artificial intelligence, and that has been discussed in great detail. Justice Vishwanath described that in great detail, the challenges with artificial intelligence, who creates, who owns, etc., etc. And that across the board in the age of ChatGPT, where I know legal drafts, I've seen legal drafts being prepared on ChatGPT. Tomorrow art will be prepared on ChatGPT. Tomorrow songs will be prepared on similar machines. Who owns what? That's an important question. That is something which we are going to see in future. Second, I also see this, and this I think is a good thing which is happening, is now the increasing and of open source systems, whereby we've seen that when first it started, I don't know how many of you know, is the Linux operating system, which was like where previously the entire regime was based on operating systems used to be owned by companies, and they would have these operating systems, they would actually hold the world to ransom. I think Linux started with it, saying that open source, you develop it, and now increasingly, even someone as close, which operates such a closed system as Apple, have now opened it up to a certain extent to allow others to develop tools. We see that with Tesla. Tesla has also grown and pushed open source systems, allowing people to develop other technologies based on the technologies which it does have, making its patent open source so people can take that and develop their own products. So that's a great thing which is coming. 3, the NFTs with Justice Shyam spoke about. Where does that leave it? What is the worth of NFTs? How do you sort of create, monetize it? How do you create, in some ways, how do you get the benefit out of NFTs? The whole question is, even today, as we are all seeing right now, I was reading a newspaper article in the morning saying that this question of NFTs haunted it so much that today the worth of NFTs, I think, is nearly zero. So but the issue of NFTs still remain as a product and as the product of how to monetize it. Because the entire IP regime relies on monetizing an intangible product. So if you are going to monetize NFTs, who does the intellectual property belong to? How do you monetize it? These are questions. What is the intellectual property regime based on which you're going to distribute benefits? These are questions which will obviously come. The other new technology which we are all discussing, which was also mentioned in passing, is blockchain. You know, blockchain we've been used to quite a lot. It's been used, it's been misused. But it's largely to go through this entire process of to authenticate products and to, you've heard of the VeChain solution, whereby this company has come out with a system whereby it authenticates to the entire production process that it is correct, because it's, as it's been described, it's an open ledger system, so you can track the quality, you can track the product, you can ensure that it's not copied. So if you insert a chip in a product, you can ensure that it's not copied, which is another great development of intellectual property to ensure that your copyright is protected to that extent. And I think one of the greatest sort of intellectual property issues which we face regularly in court is duplication of products. Is how do you ensure that the product is genuine? I think to that extent blockchain may be used for that purpose, so I think it's a great development. The other is what Justice Shyam spoke about, was digital rights management. So how do you manage that? That's the broad question, as in how do you manage digital rights? How do you manage the question of jurisdiction? How do you manage individual rights? That is the question which is the crux which I would like to make the basis of my presentation. As in, when you are talking about a new digital management regime which is going to govern intellectual property, who owns this property? And it's good that for once we may be thinking beyond the individual rights regime. It's a great thing. The first time after maybe the Anglo-Saxon invention of the conception of property, individual property, that for the first time you are having a challenge to it, and the challenge is coming from actually technology. Because if you look at it, Alistair McIntyre, a great philosopher, once wonderfully wrote that there was no conception of rights in Japan or even in our culture till the 19th century. So where does that leave your individual rights concept? Now the entire conception of having ownership of intangible rights because of what you produced is in many ways a product of the West. To look at IP now in this borderless world that we are in. One is to look at it from a communitarian perspective. One is to look at it from an individual perspective. Now, all of us know even today, IP, the Europeans usually look at it from European Union usually looks at it from a communitarian perspective, saying that rights are to be protected. inventors are to be protected, the origins. What I would call a postmodern invention, which according to our culture is possibly not a postmodern. It is the system which we as a civilization were used to, and because we've invented a large number of products throughout our history, but we've not got intellectual property over them. We didn't take out a patent or copyright over them. So maybe that's time that we look at some future model. But in designing the future model that we are looking at, there are some things which I would like to keep in mind, which are the challenges which we are going to face in future. One is we have to ensure there's accessibility versus exclusivity. The intellectual property regime that we have today, whether we like it or not, is based on exclusivity. It has excluded people from access. Now, whatever regime that we have today, I would see it err more on the side of accessibility. Because what it has resulted in, irrespective of, it's wonderful that we are in this room and we're talking about it, is the conception of digital divide. There have been people who have access to the products arising out of intellectual property, they have benefited. So it's time that we have to ensure. And what is the objective? The objective is to ensure maybe we need a more societal based looking at the intellectual property regime. Second, another issue which we need to flag, and it's important for us to flag, is we should ensure that there is no cultural appropriation. We are seeing, and this is an issue which is haunting us, is that multinational companies are taking Indian products from the global south, patenting them, and this is happening in a borderless world, and then commercializing them. We have to have a regime which takes that into account, so that it doesn't happen that companies which are based in the global north use the indigenous knowledge, the products of the global south, and then use it and sell it back to the global south at a huge profit. And the intellectual property regime is a facilitator of that. We have to ensure that protection against that. We also have to ensure that there is no patenting of life and the commodification of that. One of the great things about the vaccine which happened, this is what it was, the vaccine of the COVID vaccine was a wonderful invention. It was an invention which all of us could be proud about. But the game which was, I don't know how many of you know, which was played at the time of the COVID vaccine, when the original plan for the invention of the vaccine, when it was invented in Oxford, was to distribute the patent free, so that different countries could manufacture that vaccine in their own countries, use those invention, and they could. But it is big multinational companies got into the game and said, no, you cannot distribute it. There is that wonderful, there is that interview, which is quite freely available of you can check, is on Bill Gates saying that I got in touch with Oxford. Bill Gates was one of the founders, one of the funders of the Oxford Institute, and he got into, there's a YouTube interview. He said, oh, I said that you can't do this. So even something as crucial as the vaccine, the intellectual property regime was used for the purposes of increasing digital divide, for increasing monetary gain. So the regime which we look forward to, and a regime which is receptive to all people, I hope, would
include some of these concerns. The other is, allied to that, is that, human rights and human existence would be at a value and would be treated as a value, rather than simple profit. There has to be a payoff, and as coming from a background of Indian civilizational thinking, I would say a regime which is purely monetary and in some ways even extractionary, which has happened over the last 20, 30 years, it needs to have a human face in the global borderless digital world. And we have an opportunity to do that. We have an opportunity to frame the rules of the game, and now we have a say in it, being one of the most important players. And we should go about doing that. Now, one of the ways which it can be done under the present regime is, of course, creating Creative Commons, ensuring fair use, so that everybody gets to use whatever they use fairly. So there it becomes open source. These are the ways of doing it under the present regime. But I would like to conclude by just saying this, and I'm sorry for this very short presentation, but I would like to say is that maybe, right as I began, there needs to be a rethink as to who owns these properties. And why do you invent things? What is the sort of benefit and profit you should be allowed to get from these inventions you have? We have a 5,000-year-old civilization, and this civilization invented wonderful things, and some of these have been replicated and taken even in the West. And we invented this, but we did not copyright it, we did not patent it. And we believed in our philosophy that what you invented, people added to it, and therefore knowledge grew by people adding to it. You did not reserve it to yourself and monetize it. The age which we are in has, of course, myriad challenges. It has myriad challenges, some of which are profound as to where we are as a society. It can go either way. Where we are standing now, it can become an extremely commercial, transactional, consumerist world. And I think, I practiced IP, and it's a wonderful subject, but it also has been one of the drivers of commercialization and consumerization of the world as we see today. Maybe we need a break. And maybe a more fairer regime which distributes the benefit of intellectual property to everybody in the planet, and which takes into account human lives, is very important. And maybe, as I say, we need to go back in order to go forward. The more things change, the more things should remain the same. Thank you very much.
For presenting a different dimension, it was a very useful address, attempt to bring humaneness to commercialization of intellectual property. With that, may I now invite our last speaker for the evening, Mr. Saikrishna Rajagopal, established name in the IP legal fraternity, and Sai, over to you.
Thank you, sir. Honorable Justice K.V. Vishwanathan, Honorable Justice Manmohan, Justice Suman, Shyam, my dear friend Vikramjit, ladies and gentlemen, I'm deeply honored and privileged to be part of this wonderful panel, and for this I'm very, very deeply grateful to the Bar Council of India. The legendary copyright scholar and lawyer, Mr. David Nimmer, once famously remarked that the internet is one gigantic copying machine. Now, while the internet throws up tremendous opportunities to monetize intellectual property, statement very succinctly captures the potentiality of the internet to actually undermine IP in a very, very serious way because of the anonymity that the internet accords to a potential infringer. So what are the issues involved? Do we need a new set of laws? The tsunami of opportunities that the metaverse or the internet has presented will need to be stacked against the substantial risks to intellectual property itself. Through this session, I hope to give you a very quick flavor of some of the issues that are involved. And I know we are running really short of time, so I've decided to abandon my slides and just take you through some of these issues. Some of them have already been dealt with. The first issue that I'd like to deal with is the issue of jurisdiction. Now the question that arises is, which court would have jurisdiction when dealing with an infringing online location? Is this on the basis of mere access to a website? Or do we need something more? In the year 2003, the Delhi High Court, to the Casio case, said that mere access is sufficient. So if you're able to access a website from a particular jurisdiction, that mere access alone will clothe the court for jurisdiction. Then in the year 2007, there seemed to be a shift in the India TV case. For the first time, the Delhi High Court sowed the seeds for what we call purposeful availment of the jurisdiction. It is not necessary, it is not enough, therefore, to merely have access from a jurisdiction, but there must be some interaction or connection between the jurisdiction and the infringing site. So it could be subscribers, it could be, for example, the infringing location dealing in terms of rupees, it could be the making available of Kannada films or Bollywood films. And on the basis of this criteria, it could be assumed that there is a purposeful availment of a particular jurisdiction. In the year 2009, a division bench of the Delhi High Court, in the Banyan Tree case, had occasion to once again consider this question. And in the Banyan Tree case, the division bench said that what is necessary to look at, I think it's an extension really of the purposeful availment test, that you need to look at the effects test. In other words, can a transaction be potentially consummated between the infringing online location and the jurisdiction, is the question that the Delhi High Court posed. So once again, the Delhi High Court reiterated that mere access to a website is not sufficient. And finally, more recently, in the Tata Sons versus Hakuna Matata Foundation case, it appears to a lot of us who are practicing before the Delhi High Court that in paragraph 17 of the judgment, we seem to have reverted back to the access test. And on the basis of this division bench ruling, we see single judges of the Delhi High Court now allowing jurisdiction on the basis of mere access. Although on facts, if you look at the Hakuna Matata case, there were several criteria or facts that pointed towards the Delhi High Court or India itself. There were several India-specific facts, or there were several India-specific interactions that the website in question had. But as a matter of law, based on paragraph 17, it appears that mere access is sufficient. As far as blocking of rogue websites is concerned, we have the author of the judgment shown here in the UTV case. This judgment has been extensively dealt with, but I just want to make one point as far as this judgment is concerned. Based on the strength of this judgment, and we often call it a springboard, we now have a recent judgment or order of the Delhi High Court resulted in a blocking of a website on a global basis. Because if you look at the UTV case, as Justice Manmohan pointed out, these actors or bad actors are not subject to any jurisdiction, are not subject to any laws. It is impossible to enforce an order. So what do? You devise a mechanism where these websites are blocked from access as far as India is concerned, through the ISPs and the DOT and MIT. But what the Delhi High Court did in this recent order is to order the suspension of these domain names itself, with the result that as far as those domains are concerned, because suspension has taken place, and I'm happy to let you know that some of the registrars have already suspended these domains. These websites with those domains are now effectively blocked the world over. Now, questions may arise as to whether that's excessive, and there's a right to information, and so on and so forth, but that's an ongoing debate. But this is what has happened as a result of the UTV line of cases, that we now have a situation where the domain name itself stands suspended and consequently the website blocked globally. Another interesting issue that arises is with respect to Google AdWords. Now all of you are familiar that when you search, say on the Google search engine, you see a lot of ads popping up. Now the reason why these ads pop up is because competitors have been adding keywords in the AdWords program of Google. Now these keywords, for example, if you're a footwear manufacturer, it could be footwear. If you're a dental cream, it could be dental cream. But you could also, for example, use trademarks or brands belonging to your competitors, so that when somebody looks for your competitor, your ad pops up as well. And the question that arose is whether this is used within the meaning of the Trademarks Act, and whether such use is within the mischief that the Trademarks Act seeks to preclude. The Delhi High Court, a division bench of the Delhi High Court, in the DRS logistics case, or what you call the Agarwal packagers and movers case, has held that yes, use as a keyword amounts to trademark use, but in order that it is actionable, there must be an evidence of copying, there must be an evidence of confusion or deception occurring. So with the result, the legal position that you have at hand is that the use of a trademark as part of a AdWords program, although it is used within the meaning of the Trademarks Act, would not be actionable unless the plaintiff is able to additionally demonstrate confusion and deception. Now coming to standard and essential patents, this is again a topic that Justice Manmohan dealt with extensively, and Justice Vishwanathan dealt with it as well. But I wanted to spend maybe a couple of minutes as far as SCPs is concerned, because this is really a topic that's close to my heart. The last decade or so has seen an emergence of a new species of patent litigation, which you call SCP litigation. Now, what is peculiar about this kind of litigation is this. The patentee says that his patent maps onto an industry standard. Now, if the patent maps onto an industry standard, then any other player in the industry which is desirous of complying with these standards will have no non-infringing alternative but to emulate the patent. Now, the patentee in turn, because his patent maps onto the standard, has given an undertaking to the standard setting organization that it will license these patents on a FRAN basis. And what this actually means, and this is developed as a line of through case law, that in a standard and essential patent case, a patentee is not entitled to an absolute order of injunction. If you look at the line of cases, for example, including the UK Supreme Court, the defendant, while an infringement is found against him, the defendant is given the option of choosing a FRAND license at a FRAND rate prescribed or set by the court. And it's an injunction will issue, or the defendant will be saddled with an injunction only if he does not choose to pay in terms of that prescribed set FRAND rate. Now the problem that we have at hand is this. Because patent rights are territorial, but products are sold on a global basis, patentees are having to sue in multiple jurisdictions. And in multiple jurisdictions, they will ask or request the setting of a FRAND rate. Now, in all of these jurisdictions, the question that will arise is as far as the defendant is concerned, which FRAND rate does he go by in order to avoid an injunction? The UK position currently is that the UK courts have taken the view that unless you agree or undertake to pay in terms of a FRAND rate prescribed by the UK court, there will be an injunction. So the defendant has no option. The defendant can't turn around and say, look, you applied in multiple courts. I will go by the least rate. I will not go by the highest rate. So this is one major issue that is an emerging area of debate. The other question that arises is if patent rights are really territorial, then how logical is it that courts have proceeded to fix FRAND rates on a global basis with respect to patents not covered in a particular territory? That's the conceptual sort of debate that's now pretty well settled in the UK, and I think reasonably well settled after Justice Manmohan's judgment, both in the Intex case as also in the Nokia case. But that, of course, was in the context of a pro tem order. So we are hoping that a little window of opportunity is available to defendants to kind of readdress that position. The next point that I want to focus on is the IP challenges involved in AI and the metaverse. There are some fascinating legal issues will arise. So, for example, in the context of AI, can AI generated material be conferred with intellectual property protection? Now, if you look at it traditionally, the idea or objective behind intellectual property protection was to reward human creativity, human ingenuity, human investment. And the question that has arisen is whether artificially created material through artificial intelligence would be capable of a copyright protection or a patent protection or a design protection. As far as copyright is concerned, I think there is a reasonable amount of consensus developing that it has to be a natural person. It has to be human creativity, as opposed to creativity involved through an artificially generated process. I'm told that in India, an application was in fact filed and a registration actually took place, but now the Copyright Office has issued a show cause notice saying why should it not be withdrawn. As far as patents is concerned, Justice Vishwanathan spoke about the Dabus software patent. South Africa has granted it, but I'm told in South Africa, the scope of examination is not so rigorous. So everything goes through to start with. But in Australia, the High Court there is rejected. In India, I'm told the same pre-grant opposition is still pending consideration. So we don't have a final decision yet as far as India is concerned. The question that arises is copyright infringed in products or materials generated by AI. So, for example, I may request a AI tool to give me a picture of Amitabh Bachchan in a Rajasthani costume. Now, the way this will work, as you may know, is that these images of Amitabh Bachchan are actually stored as data points. And then when a request is made, these data points are retrieved and then created into an image that is finally presented to us. Now, this would necessarily involve reproductions, temporary storage of hitherto existing copyrighted material or photographs, and therefore arguably amount to copyright infringement. I've come across cases where you can tell an AI tool to actually give you passages from books, and it will rattle it out. Again, I have absolutely no doubt in my mind that unless you have a new paradigm shift, new rules of engagement, applying traditional, conventional copyright law, this will arguably amount to infringement. Now, if you look at, for example, AI, in the creation of AI, when a tool is created, it requires a lot of learning, and that learning is achieved by having regard to a lot of material that the AI developer will scrape off other information locations. And all of this may again be subject to IP. Now, for example, in the US, when this question arose, under their fair use provision, you must remember that in the US, they don't have a Section 52 version of our Copyright Act, where Section 52 articulates exhaustively all those circumstances that would qualify for exemption from infringement. In the US, you have the broad three-step test, and the courts will look at whether within the corners of the three-step test there is infringement or not. In the US, this data scraping has been held to be an exception and fair use, because what is being scraped is not in competition with the original copyright owner. It doesn't affect their revenue stream, their primary revenue stream. That appears to be the logic. Now, our works created or used in the metaverse, such as NFTs, which Justice Suman spoke about, could it be the subject matter of IP protection? Most certainly. For example, an NFT could just be a PDF of representing an artistic work. It is certainly the subject matter of copyright protection, and for that, I believe we don't need any change. The existing law itself should be able to address that. But in the context of, for example, virtual design, so, if you are in a universe or a metaverse, which has a certain design or appeal, which has certain products in that metaverse, which have a certain look and feel, the question that arises is whether those articles which have a particular shape, configuration, or surface pattern which appeals to the eye are capable of a design registration. Under Indian law, arguably no, because we would need a finished article to be capable of design registration under Indian law. And therefore, unless you have an amendment, arguably that may not be possible as far as India is concerned. Artificial intelligence and personality rights. So the Delhi High Court, for example, recently had occasion to deal with a situation where Mr. Anil Kapoor was the plaintiff. And the case of the plaintiff was that, inter alia, that his images, his persona, his likeness was being distributed, was being made, for example, through means which are used through artificial intelligence. And the Delhi High Court, striking a distinction between the earlier judgment in the digital collectibles case of Justice entitled to an injunction. But Justice Amit Bansal in the digital collectibles case said that a player's image or player's cricket statistics or personal statistics would be incapable of a protection in the context of facts of that case, because after all, it's a game that's being played. It's an online game that is being played. If one has to refer to Virat Kohli, then it is perhaps a defense to use an image of Virat Kohli. Now, these are all areas that are severely grey, and I'm sure will reach the Supreme Court at some point of time. There are arguments on both sides. We need multiple technical sessions to just, debate these areas. Now, there are works, and somebody remarked, I think it was Vikramjit who said, it's possible for example, a song. I don't have a singing voice at all, but I can turn down and request AI to take samples of my voice and then try and sound like Kishore Kumar. But the question is, let's assume there is such a song and it comes on Spotify or what have you, Ghana. Is this a violation of copyright? It is a violation of copyright because the original sound recording may not be used, but the lyrics and the music composition are being used. Because Javed Akhtar would have written the lyrics, A.R. Rahman would have set those lyrics to tune, and therefore there's a music composition copyright. And therefore, arguably, a case of copyright infringement set up. So I'm just trying to give you all a flavor of what are the possibilities. Now, IP and the metaverse. I think almost all the speakers refer to the Hermes International case, the Meta-Birkins case. But this again raises some fascinating jurisprudential issues. Now, when you file a trademark case, the plaintiff will have to establish a priority of use or a priority of reputation in India, because trademark rights are territorial. So therefore, the plaintiff will have to show that he was the first person to adopt the trademark in India, use the trademark in India. Or in the alternative, show that a reputation spilled over into this country prior to the defendant's adoption in India. That is the Prius test that has been laid down by the Supreme Court. Now, in a metaverse context, a fascinating issue arose. The court said that it's possible that the plaintiff was only in the physical world, not in the virtual world, but his reputation is spilled over from the physical world to the virtual world. So there is a spillover of reputation from the physical world to the virtual world, meriting protection. And that's what resulted in a protection as far as the plaintiff is concerned. Courts may also recognize that the metaverse is a legitimate zone of expansion. We all are aware that in the physical world, companies do expand into other areas, other lines of business. So similarly, a court could come to the conclusion that the expansion of a particular business into the virtual world is covered by the doctrine of legitimate expansion and therefore protected. All the rights, trademark rights that accrue as far as the proprietor is concerned in the physical world would accrue in the virtual world as well. And finally, my last point is with respect to exhaustion of intellectual property. This is particularly important when we look at intellectual property in the context of a borderless world. What is exhaustion? Exhaustion, the doctrine of exhaustion, merely means that at some point the intellectual property owner loses his or her ability to control further sale or distribution of the product relying on the intellectual property right. And this is governed by the first sale doctrine. So once a product embodying a trademark or a design is sold in the market, then it will be possible for any of us to buy and sell and redistribute it without the IP owner having to authorize the sale because IP rights are exhausted in this. Now, India follows an international exhaustion principle as far as trademarks is concerned and as far as copyrights are concerned. Sorry, not copyright, trademarks and patents. Copyright, we have a different standard which others come to. As far as trademarks and copyrights are concerned, as patents are concerned, so long as it's a legitimate product, I can import a product from anywhere in the world and bring it into this country. The plaintiff or the trademark owner can't turn around and say, look, I have some other licensee in India. You can't sell in this territory. So long as it's a product sold anywhere else with the consent of the proprietor, it can be freely brought into India. And likewise, from India, you can export it to some other place. That's international exhaustion. Some countries follow regional exhaustion, like in the EU. They can, the product can be freely sold or distributed within the EU, but outside it does not stand exhausted. As far as copyrights are concerned, and I'll conclude with that, we do not follow international exhaustion. It is because the Copyright Act in section 19 has a specific stipulation enabling the right owner to divide his or her rights in terms of territories. And if you look at section 14, the right of issuing to the public would exist regardless of whether the copy has been sold on earlier occasions or not. There is a specific language to that. Thank you very much. Thank you, sir. That was an illuminating address. Maybe we could have the benefit of your slides by email. If you're okay with Bar Council can take it and distribute so youngsters, whosoever you want to see it, because coming as it does from him, dealing with this day after day. So I think that has been a fascinating session. Thank you very much. I don't know whether we have time for
just 1 minute. It was a feast to us. In fact, we have heard very knowledgeable and immensely enlightened legal luminaries on a subject of very crucial and critical importance. It's complex and complicated, but explained with elucidation and amazing clarity. Thank you very much, sir. We are immensely grateful to Honorable Justice K.V. Vishwanathan, Honorable Justice Manmohan, Honorable Justice Suman, Shyam, and the Honorable Speakers, Shri Vikramjit, Banerjee, ASGI, and Mr. Saikrishna, Rajagopal. Thank you very much, sir, and thank you to the audience. The audience has been waiting for you since 8 o'clock in the morning, and particularly for
Thank you.
Thank you.